Flashback to when I was 23, I'd just bought my first property. I was pumped and I was proud and I thought I was building wealth. Hooray! But I had no idea what I was really walking into. And turns out, buying a house also means stepping into this massive regulated legal machine. And I barely understood any of it. I had no idea how close I was to actually losing everything. By the time I had gone through it, I'd lost over $35,000 in unpaid rent and legal fees. I was 30 weeks pregnant at the time during my tenant's eviction. I was shoveling literal dog shit out of the unit, and that really sucked. Besides the money, the stress was actually worse. The exhaustion was what really broke me, and just the endless waiting and waiting around, the not knowing and the feeling of being totally helpless while my own money was draining away. So today I want to talk about what I wish I knew back then so that you don't make the same mistakes. If you're thinking about buying a rental property in Canada, or honestly, if you just bought one, I need you to pay attention because I've worked with thousands of housing providers through my company, Openroom.ca, and the next 6 things keep blindsiding people again and again and again. Everybody talks about finding that right deal, getting the financing. That stuff matters, but legal traps, the hidden debts, the things buried in the system that no one else tells you about but actually costs you thousands of dollars. You need to know about them before you buy. So today I'm going to walk you through all 6, starting with a hidden debt that can transfer to you at closing even if you never created it. Then I'll show you how one paperwork mistake can let a bad tenant come after your personal home and savings. And later I'm going to explain how you can buy a property and inherit a tenant you never chose, someone who's legally protected from eviction. That one is pretty wild. All right, let's dive right in. There are debts attached to the property that will become your problem the moment you sign the closing papers, even if you didn't create them, even if you've never met the person who did. I'm talking about utility debts, and specifically in Ontario under the Municipal Act and something called Ontario Regulation 581/06, which is basically a rule that says municipalities can move unpaid water, gas, and sewage charges onto the property's tax roll. So what does that mean in plain English now? It means that if a previous owner's tenant ran up a massive water bill and never paid it, the city doesn't chase the tenant. They put the debt on the property, and now it's sitting there waiting for you. That's you, the buyer, to deal with it. And it gets ugly pretty fast. So in Ontario, they add a 1.25 monthly penalty on top of the balance, plus an approximate like $50 or so fee. All of that really adds up. And if you don't pay, the city can eventually trigger a tax sale of your home. Yes, your home that you just purchased for someone else's water bill. Okay, I know, that sounds extreme, but I've seen it happen. And the worst part is you can't really force the city to go after the tenant for it. So here's what you do. Before you close on any property, you request something called a water certificate from the municipality. That's it. It's one document that shows any unpaid water or utility balances on the property. And it could save you thousands of dollars. I'm scoping this to Ontario because I know the rules here, but the principle of inherited water utility debt shows up in other provinces too. So wherever you are, ask your lawyer about it before you close. It's the simplest, cheapest protection you can take, and almost nobody does it because it is rare that it happens, but it can happen. And that's what really gets me. This is step 1. Before a single tenant moves in, before you even turn the key, and most people have no idea. But hidden debts are only one piece, because the next thing that can go wrong, and this one is really scary, is how your entire business is structured. And if you get this wrong, a bad tenant doesn't just cost you property, they can come after everything you personally own. All right, this next one I see constantly, and I want you to really hear it. When you buy a rental property, you have to decide how you're going to own it. And there are basically 2 paths. I like to think of it as the backpack versus the bouncer. Okay, so path 1 is the sole proprietorship. That's the backpack. It's simple, it's cheap, likely when you open up your basement for rentals. You and the business are the same thing. Like you're just running a shop out of your backpack, easy to set up, no corporate paperwork. The catch is that you have unlimited personal liability there. If a tenant sues you or you get hit with a massive judgment, creditors come after your personal car, your savings, your home, everything. Path 2 is a corporation, and that's the bouncer. A corporation is a separate legal entity. Think of it like having a giant bouncer named Liability Shield standing between you and the business. It costs more to set up. It needs proper bookkeeping, payroll, dividends, all that stuff. But if something goes wrong, the bouncer takes the hit, not you. Now, I'm not saying everyone should actually incorporate because it's a lot of work. That's not what most people want to do, and it's not always actually the best route to go down. It's a choice made with the trade-offs. But you need to understand the stakes before you buy, because if you go to the sole proprietor route and things go completely sideways, there's no shield between your rental property problems and your personal life. Even if you do incorporate, there's a paperwork trap that can undo all of the protection in a second. It's called the name game. And I see this one all the time. If your property is owned by a corporation, let's say My Rentals Incorporated, but you put your personal name on the lease or on the legal notices you file, your entire case gets thrown out. Like everything you filed, yep, gone. Months of paperwork wasted because the name on the paperwork doesn't match the legal owner of the property. And that's your incorporation. And it goes the other way too. If you call yourself the landlord on the paperwork, but the property is actually owned by 12345 Ontario Inc., that's also wrong. It's like showing up to court with someone else's ID. They'll just send you right home. And this isn't just an Ontario thing. I believe actually this applies anywhere in Canada. If the name on the paperwork doesn't match the legal owner, you're in trouble. So before you buy, figure out your structure, and once you do, make sure every single piece of that paperwork, the lease, the notices, the filings, has the exact name on it. Not your name, not a nickname, the legal entity name. So that's the structure piece, and it's pretty big deal. But the next thing I need to tell you about is something most buyers have never even heard of. You'd think buying a property means you choose who lives in it, right? No, that's not actually how it works, because you can actually buy a place and discover that someone is already living in it as a legally protected tenant you never agreed to. Alright, this one is kind of wild, and it's becoming more and more common because of what's happening in the condo market right now. So picture this. Someone buys a pre-construction condo. You know, one of those units is still being built. They put down their deposit, they sign the purchase agreement, and eventually the building is done enough that the developer lets them move in. This period is called the interim occupancy. They're paying fees to the developer, they're living there, but they haven't actually closed on the mortgage yet. And then the interest rates spike, which, if you've been paying attention to the last couple of years, you know exactly what I'm talking about. Suddenly, this buyer can't get approved for the mortgage anymore, the purchase agreement falls through, and that person doesn't just pack up and leave. Because under the law, once they've been living there during interim occupancy, but the deal falls apart, they're actually still considered to be a tenant under the Residential Tenancies Act. And what is that? That's the law that governs the landlord and tenant relationships here in Ontario. So the developer or whoever buys that unit next cannot just change the locks and kick them out. They have to go through the full eviction process at the landlord and tenant board. They have to file what's called the Form N8, wait months, and in the meantime, this person who was supposed to be the buyer is now a tenant that nobody chose, nobody screened, and nobody planned for. You become an accidental landlord to a failed purchaser. And the legal process to deal with it is very slow. Ideally, this doesn't happen to you because likely the developer wouldn't sell you a condo with this kind of situation in it, but just keep in mind that it could, in the rare chance, happen. For any property you're buying in the future, any property, you should verify who is physically occupying the unit, if there is anybody, and under what legal arrangement before you sign anything. A property that looks vacant on paper might have a sitting tenant with full legal protection. Your real estate lawyer should confirm occupancy status, but most buyers doesn't carefully think about this. Your real estate lawyer should confirm occupancy status, so just be careful. And look, even if you buy a property with no tenants, eventually you're gonna wanna rent it out. That's the whole point. So the next thing you wanna know is what happens when a tenant stops paying rent. I know that's what's on your mind. So because that process will eat you alive, and if you're not ready for it, it could go really bad. And I need to tell you about it. This is one that hit me the hardest personally. I know it hits every landlord the same way because I've heard thousands of them tell me the same story. A tenant stops paying rent, and your first instinct, because you're a decent person, is to wait. I mean, everybody falls on hard times, so you want to give them a chance. Be understanding. I did the same thing. I waited weeks, and I thought being patient was the right call. Had I looked back in hindsight, it absolutely was not the right call. It was the most expensive mistake I could have made. So here's what you need to know. In Ontario, if rent is due on the 1st, it's officially late on the 2nd at 12 o'clock a.m. Day 2. And on day 2, you can issue something called an N4 notice, which is the formal notice of non-payment that starts the entire legal process of eviction and getting your money back. I'm not saying this because you're heartless. I'm saying this because the legal process is agonizingly slow, and every single day you wait in the system, it works against you. By the time you file, wait for a hearing, actually get in front of someone at the landlord and tenant board, you could be looking at several months now. Months with no rent coming in while your mortgage keeps going, along with all of your other expenses for this rental property. So you start the clock immediately. Not out of malice, out of survival. Most new landlords wait weeks or months because they feel bad, and by then a professional tenant had already dug in. And yeah, I said professional tenant because that's a real thing. CBC did a couple on a story who owed nearly $100,000 to 4 different landlords. 4! These people knew the system better than the landlords did. They used delays, stays of eviction, fake disputes, every trick available to live rent-free for multiple years. They just move from one property to the next, doing the exact same thing each time, and it absolutely frustrates me. That's what new buyers don't understand. You think, it won't happen to me. Well, I thought the same thing. Every landlord who gets burned thought the same thing. This is why, before you ever rent to anyone, you need to check their court order history. Through Openroom.ca, we've crowdsourced over 55,000 court orders across Canada. You can search a name and see if they've been through the system before. Credit reports miss this stuff entirely, but court orders do not lie. And 2 rules. Start the clock on day 2 and screen like your financial future depends on it, because it does. Now, this next one makes a lot of first-time investment buyers really uncomfortable, because you'd think your lease would protect you from a lot of this. Well, you'd think, well, I'll just write a strong clause and cover myself. And I wish some of that were true, but some of the clauses you'd think are protecting you, they're legally worthless because they're not enforceable. This surprises basically every new landlord that I talk to. In Ontario, if you put a no pets clause in your lease, it's pretty much void, like legally unenforceable. It doesn't matter if the tenant signed it, doesn't matter if they agreed to it verbally. Section 14 of the Residential Tenancies Act, the RTA, says that clause means nothing. The only time you can actually take action on a pet is if it's dangerous, if it's causing severe allergic reactions for someone in a shared ventilation system, or if it's substantially interfering with other tenants' reasonable enjoyment. For example, like we're talking incessant barking at 3 a.m., not just, I don't want a cat in my unit. Now, this is interesting because in BC and Alberta, landlords can actually restrict pets. BC lets you charge a pet deposit up to half a month's rent. Alberta lets you refuse pets entirely or set specific breeds and size rules. So the rules are different depending on which province you are in Canada. But in Ontario, your no pet clause, no, is paper thin. And this is the bigger lesson. New buyers often treat their lease like it's a shield. They think, I've got everything in writing and I'm covered. But in reality, a lot of those clauses are legally meaningless under the RTA, and that false sense of security is exactly what gets people into trouble. So when things go really sideways, like you've got a tenant who isn't paying and the eviction process is dragging on for months and months, there's a move that sounds kind of crazy but sometimes makes a lot of sense. It's called cash for keys. And yeah, it's exactly as it sounds. You pay the tenant to leave. I know, you think it's extortion, but you know what? Take the emotion out of it. It's just business at the end of the day. Sometimes it is genuinely cheaper to pay a tenant $2,000, $4,000, $5,000 to leave than to keep losing rent for 6 more months while the board sorts it out. And this part is important. You always want to sign a document. The N9 is your best bet because it's where your tenant decides they want to leave. But an N11 is also great, where that's the agreement to end a tenancy form together, where you and your tenant decide on a mutual date to vacate the premise and end the lease. And the money, remember, only switches hands when they give you vacant possession. That means keys in hand, empty unit, never pay up front. Do not pay up front. Because if you pay up front and they don't leave, well, you just lost even more money on top of everything else. Please don't do it. The money only changes hands at vacant possession. So that's the reality of how the legal system actually works for landlords. And I know this all sounds kind of heavy. Trust me, I've lived through some of the worst of it, and there is actually good news here, because the landlords who do well, the ones who don't get blindsided, they build their protections before the first tenant moves in. And the tools to do it are either free or are really affordable. All right, so after everything I just walked you through, the hidden debts, structural risk, surprise tenant, the eviction machine, clauses that don't work, you're probably thinking, okay, Wee-Ting, so how do I actually protect myself? And this is the part where I get really, really excited, because this is why I had built Openroom in the first place. My hope is that every landlord in Canada starts building their protection stack before the first rent check is due. Not after something goes wrong, before. So here's what it looks like. Step 1, before you screen a single tenant, search their name on openroom.ca. We've aggregated over 55,000 records from the Landlord and Tenant Board and across the rest of the tribunals, courts in Canada. You type in a name and you see if that person has eviction history, outstanding debts, or has been through the system multiple times. Credit reports are fine, but they miss one of the most key issues, which is the rental history. Someone can have a clean credit score and still have a trail of eviction orders behind them. You don't want that. Court orders don't show up on a standard credit pull. Openroom fills that gap. And by the way, we're a government certified consumer reporting agency, not just a rogue website out there. Landlords can report the debts, and tenants can now report landlords who owe them money too, like bad faith evictions, compensations, and so on. And it goes both ways, which is exactly how it should be. Step 2, and this one I think is actually the real gold. We have a free copy and pastable lease clause content on our website, and I'm telling you, people find this extremely helpful. What these clauses do is they bake in the rent reporting side into your lease from day one. So the tenant who pay rent on time, they get to build their credit, boost their financial history, and that's a huge incentive for them. And tenants who don't pay, it shows up on their credit profile and it can start to impact them negatively. What we have seen over the last few years working on Openroom is that people care about their credit score and their financial health. So when you include these clauses in your lease from the start, you're creating a built-in accountability system. You're aligning incentives before anything goes wrong. You're preventing the bad from happening, and you're giving yourself an actual tool, not a fake clause that just gets thrown out. Look, I know this video was a lot, and I know some of it was very scary. I wish someone had sat me down and told me all of this before I had bought my first property. It could have saved me thousands of dollars. It would have saved me a year of stress, and honestly, it probably would have saved my mental health during one of the hardest times of my life. I learned all of this through the sweat, the tears, the trial and lots of trial and error. I remember the days when I sat in my bedroom, started writing out all the things, the bad thoughts in my head, and I never wish that upon anybody else. My goal here is to share everything I've learned so you don't have to go through the same mess I did. Because despite all the horror stories I just shared, and trust me, I could share more, but I'll spare you for now, you absolutely can build generational wealth and take care of your family through this. I still believe that 110%. You just have to be smart enough to learn the system before the system teaches you the hard way. So if you found this helpful, please subscribe. I put out content like this every week to help housing providers protect yourselves across Canada. And if you want to check out court orders on a potential tenant, or you want those clauses for free, some of our other templates are all available within openroom.ca. I'll drop the links in the description below. You got this, and I will see you next time.